The first matter to come before us this morning is State of Ohio versus Dashaun M. Spear. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you would like to reserve that time, then let me know when you get started. I'm keeping the clock this morning to keep you apprised of the passage of time. We've read the briefs and we are ready to see who you are.
Your Honor, I would like to reserve, just before we get started, 5 minutes for rebuttal, and let the court know as well that I would like the lead attorney on this case, Mr. Milarsek, to use those 5 minutes for rebuttal, if that is okay with the court.
Yes.
Okay, thank you. May it please the court, my name is Rebecca Black, and I am one of the attorneys representing Mr. Dashaun Spear, the defendant appellant in this case. As you are aware, there are 3 main issues under the sole assignment of error in our case on appeal today. And it is essentially 3 of the subsections of Ohio Revised Code 2929-14C4. And I'm sure you're well aware, as they were listed in the brief, of what those are. The first subsection, if you will, it's not technically listed that way in the Ohio Revised Code, I understand, is the idea that the consecutive sentences must be necessary to protect the public from future crime or to punish the offender. And the way I analyzed this in the brief was to look at this as really an issue of recidivism. And fortunately for all of us, there is the purposes and principles of felony sentencing in Revised Code 2929-12 that we are all to use when determining whether it is likely that the defendant will commit future crimes. Now, that requires the factual analysis, and I suppose I should start first by saying the standard of review which which the appellate court is to use is just simply stated in statute. Under 2953.08, I'm sorry, 2953.08 G2, it's the idea that you must be clearly and convincingly able to find that the record does not support the sentencing court's finding under the section of the code I discussed in my brief. And that does not support is what makes this case interesting to me. It's not as if we are given the words sufficiency or manifest weight, words we all recognize and have loads of case law to explain. The idea that it does not support, I suppose I would argue that it is more to be understood more as an issue of sufficiency. Is it possible for the originating court, when determining the proper sentence, to even do the required analysis, to say to all of us that yes, I have examined the requirements under the Ohio statutes and there were facts presented on the record for me to make whatever the decision was. In this case, it was a decision that involved 41 years before Mr. Dashaun Spear will be eligible for parole. And I would argue that at least 10 of those years should run concurrent as opposed to consecutive. If you look at, I believe it's page 11 of the transcript, we're discussing the prosecution discusses one of the 2 victims in this case. This is the victim who lived, which is why Mr. Spear was only charged with attempted murder for this person, Mr. Alicio Samuel. And the prosecution's discussion of how Mr. Spear acted as it relates to Mr. Samuel show that, even the prosecution was unclear as to whether or not Mr. Spear, the defendant, had the weapon and actually did the shooting. There is the defense, of course, saying later on in the transcript of the sentencing hearing that, no, he was there, he is complicit, and he accepts his role in this. Again, displaying the remorse that's necessary when looking at other subsections of 2929.14C4. But as it relates to whether or not the facts were even presented to the court in such a way that they could determine that that they could determine the kind of analysis I went through in 2929.14C4 is what's important to note. And if it's not there, simply not in the record for the court to have made those conclusions based on the facts that were given to the court, I would argue that it is improper to find that consecutive sentences should be imposed.
I get from the brief the flavor of Mr. Spears saying I was just complicit, I'm going to take responsibility for being complicit in that particular act. Based on what the trial court had in front of it at sentencing, the trial court did not believe that that was credible. I understand that this was a plea situation, so I understand that we don't have a trial, and we're not arguing about what was found by clear and convincing evidence, but I get the feeling from the pre-sentencing report or whatever else was in the contemplation of the court at the time, that this comment that I did not shoot Mr. Sham, the survivor, I did not commit this act personally, but I was complicit, the court just didn't believe that was the case.
And that would be entirely possible, but I believe there is another possibility to consider about how the judge viewed those statements, and it could be that to the lower court, it just didn't matter. Because admittedly, of course, he was present and complicit for the murder, that given the light of those actions, the attempted murder made up his mind on one set of facts. That is another way to view what was available on the record.
But we need to say that the argument is we need to say that this was clearly and convincingly not supported. This imposition of 10 consecutive years for this attempted murder.
Yes.
The brief makes note that none of the facts that came out during sentencing supported the findings under the C4 subsection.
Yes.
But there was more before the court than just what was said at sentencing, correct?
There was the pre-sentence investigation report as well as what was said. There were no other, I believe there was a motion to suppress hearing that you should have the transcripts for.
Is this the PSI part of the record?
Yes, it is, Your Honor. I saw it, part of the record myself. Another point I would like to make about the brief is that, again, that first section of 2929.14C4, the idea that the consecutive sentences are necessary to protect the public from future crime or to punish the offender. I can only address what is necessary to protect the public from future crime. I'm not trying to tell the court what is perhaps necessary to punish the offender, but even in parsing what must be considered, it does not appear that every aspect of that, as it relates to both of the crimes he pled guilty to, are there, particularly as it relates to Alicio Samuel. And if it is an issue of the court viewing the credibility of Mr. Spears' admission of complicity, shall we call it, the prosecution did not provide enough information in its sentencing in its arguments at sentencing to show that Mr. Spear was necessarily lying to the court or being disingenuous or any other mixture of dishonesty there about his statements. There was simply not enough there.
And you are just now reaching your 5 minutes of rebuttal time.
Your Honor, then I would simply close in saying that there are many options available to you as the appellate court under 2953.08, and including in that is simply to remand it for further consideration. And I would encourage you to do so. Thank you.
May I please support Assistant Prosecutor Rachel Richardson on behalf of the state. Your Honors, the trial court had all of the information it needed before it to make the necessary statutory requirements for his sentencing factors in this case. Mr. Spear committed a horrendous murder. He broke into a man's home. He set up the murders. He shot a person in the head at least 2 times, which was witnessed by two separate witnesses, which the prosecution offered as 2 witnesses who would testify had that been necessary. And then there's also an allegation that the defendant was either standing next to or was the actual shooter of the surviving victim in this case. And it's unfortunate the victim was shot in the back of the head, or he would be able to identify which of the 2 gentlemen was the one that shot him. In this case, we are lucky that we have 1 victim available to testify. However, he wasn't required to testify because this is dealing with a plea. The defendant admitted his guilt in this matter. However, as has been noted in the brief and was noted on the record in the transcripts, on pages 33 and 34, the defendant states, "I'd just like to apologize once again to family members of the victim. I'd like to apologize to the state of Ohio, to the court, to my family for the pain I caused everybody from my mistakes, my actions. Once again, I didn't go in there to hurt anybody. I went in there to rob someone. And when I seen what occurred, I stopped. I didn't want any part of it. I apologize for my mistakes and for just my foolishness and my non-ability to say no to these actions. I just asked for mercy from the court." The court responded to this by saying, "So it's confusing to me, Mr. Spear, why others would say you were the person who was the triggerman and would say I didn't do that at all. Your lawyer is saying that they said those things to basically get themselves out from under the hook or because they had other motives." Defendant, "Yes, sir." The court, "So you're saying all those other people that said you were the shooter are lying?" The defendant, "Yes, sir." This is prior to the court sentencing the defendant in this matter and determining that the consecutive timeline was appropriate. The defendant here is not admitting to any fault here at all, really. He's saying that he didn't mean for any of this to happen, that he wasn't responsible for any of the shootings. He's not accepting responsibility as defense counsel would maintain for one of the shootings. He's actually saying here that he didn't do anything wrong. However, he's already pled guilty at this point and admitted his own fault. The state is not required to reassess every single element of a case when a defendant pleads guilty and accepts guilt. And in this case, the trial court is not required to go through why every single mitigating factor was not satisfied by the defendant. The trial court is merely required to consider these factors. Sufficient evidence was presented for the trial court to make a consecutive finding, and all of the issues that defense counsel raises here were available to the trial court when it conducted its sentencing. There's nothing here to suggest the defense counsel didn't have information available to it at the time of sentencing. There's nothing to suggest that the trial court didn't take this information into consideration. In fact, the trial court admits that it took into consideration information in the pre-sentence report, information available to it at the time of sentencing, information presented by the victim, information presented by the defendant himself. It's unfortunate the defendant didn't accept responsibility here as a mitigating factor. However, that's not the case. when defense counsel states there's no adult record, I mean, let's just review that he was only 18 for 6 weeks when the crime did occur. So again, not having an adult record is not as significant as it would be to someone who's perhaps older than that at that time. Also, he did have a juvenile record, which the court was aware of when it reviewed the pre-sentence report. The court was also aware of any allegations of drug use. However, there's also nothing here to connect the drug use to recidivism or future crime. The defendant didn't admit he had a problem and something that would cause future criminal activities. Again, there's just nothing here that would suggest the trial court conducted anything other than an appropriate sentencing factor analysis. There's nothing to say that there was insufficient evidence. Frankly, there was plenty of evidence for the trial court to review. The most heinous, really mitigating factor alleged by the defense counsel here is that the victim caused the crime themselves. This is a crime that occurred in the victim's own home. The victims were brothers. It's not to state that the victims were innocent actors of society. However, the first shooting occurred while the victim was engaged with a young lady. Certainly wasn't breaking out of the house and charging anyone. He was up in bed and was shot in the head. When the second shooting occurred, he was on the floor unresponsive. And when the victim was shot, the surviving brother, he was shot in the back of the head after he's begging for his own life. There was time taken to search the property for extra things to steal. But again, there's nothing here that would suggest that a consecutive prison term wouldn't be appropriate. And there's nothing to suggest that the trial court didn't take this information into consideration when it decided that the defendant was lying. There's nothing to take into consideration that the defendant didn't have a sufficient mitigating hearing. There was sufficient evidence presented. The trial court conducted the appropriate analysis. If there's nothing from the court, the state would ask that the trial court's decision be affirmed. Thank you.
Morning, Attorney Don Malarczyk and I, along with Rebecca, represent Dashaun Spear. Dashaun Spear had never set foot in a high school. He was 6 weeks into the age of majority when this crime occurred. Dashaun had some significant mental health issues. The pre-sentence investigation report talks about his ADD, his ADHD, and his bipolar issues, which were untreated at the time of the offense. Dashaun was raised by a single mom with 5 other brothers and sisters. If you saw Dashaun, you, like me, might initially be shocked by his size. He's a little guy. And the PSI talks about Dashaun being picked on for being a little guy growing up, and for being bullied and teased because he had to wear his mother's clothes to school because he didn't have the money to buy his own clothes. And being made fun of because his 5 brothers and sisters had 5 different fathers. And bouncing around from home to grandmother's house to back to his mom's house as a child.
And this is all in the sentencing transcript?
Yes, Your Honor.
Thank you.
It is, yes. And also, Dashaun was a young man who turned to drugs. At the age of 8, started experimenting with marijuana and reported a daily use at the time of the crime. He was talking about being on lean, this horrible mixture of codeine and marijuana and benzodiazepam. And I point that out because I'm sensitive to the trial judge's concern that there wasn't an appropriate demonstration of remorse, and the trial judge had not been convinced that Dashaun wasn't the shooter. And I point all that out because you have to, I think, look at these factors of Dashaun and what he's capable of articulating to the court. I'm reminded of a quote by Albert Einstein, and Albert Einstein said, if you judge a fish by its ability to climb a tree, the fish will spend its entire life thinking it's an idiot. To expect that Dashaun Spear could come into court with his upbringing with his lack of education, with the debilitating pillars of substance abuse and mental health issues ravaging his young mind, to expect that Dashaun is going to come in and articulate in a manner that is genuine some statement that convinces the court of who he is and how he got here is, I think, just simply too much to ask. What Dashaun did is what he could do in the best way possible to demonstrate remorse, and that is plead guilty, knowing that he was walking into a life sentence. The issue before this court is whether or not that 10-year additional sentence is enough, or too much, I should say, apologize. And we believe the evidence clearly and convincingly supports the fact that it is too much, given Dashaun's mitigating factors, as well as his role in the offense, which I don't believe the court adequately concluded. There was, I'm sorry.
Counsel had mentioned that one of the options under the statute is for the appellate court to send it back to the trial court after a finding that it was clearly and convincingly contrary to law to impose some consecutive sentences. What would be the instruction that the appellate court gave the trial court on remand? Take a look at the facts you took a look at. We don't think they support your finding?
Yes. Yes. I don't think that the record supports the finding that Dashaun Spear did not adequately demonstrate remorse and was the principal offender as to the attempted murder charge. And I point out in the record, after I had an opportunity to stand up and present evidence to the court about why I felt Dashaun Spear was not the shooter on the attempted murder charge, Judge Parker said, is there any reason to believe that counsel has misrepresented the facts, or is there anything else that the prosecution wants to put on the record in terms of factually what happened here? And the prosecution said no. So I think the court has to assume that my recitation of the facts is consistent with what happened here. Nevertheless, the court on its own said, I just don't believe you. So when the court gives the prosecution opportunity to say, is Mr. Milarczyk wrong when he argues that Dashaun was not the person who shot Mr. Samuel, and the prosecution says we don't have anything else to offer, but then the court finds essentially that Dashaun was the principal offender and consecutive sentences are necessary, I don't think that that finding is supported and is clearly and convincingly wrong.
And counsel, you have reached the end of your rebuttal time. Thank you both.
Thank you.
Thank you all for your presentations this morning. Court will take the matter in advisement, issue a written decision, which will be mailed to both parties as well as posted on our website and House Supreme Court's website.